Welcome to Dolly Talk. This is Dolly. I think everything's working right now. I had some last minute mic issues, so if it sounds weird or anything, please let me know. What's wrong with my audio, Napka? Can you hear me? Is it still echoing? Hi, Lexi. How are you? Is it still echoing? Or is it better now? One or two? Like you added a sound stage. Any different? Anything? Maybe? Cool. What we're doing today is Judge Middleton again. So I will start that. Hello? Hello, 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 hello. Can you hear me? No? Okay. I'll just change. One sec, guys. One sec. Oh, it's fine now? Oh, wow. Okay, sweet. Thank you, Mavka. All right, I am using a mixer, so I wasn't sure if it was working or not. So thank you, guys. That is awesome. All right. We are going to do a motion for a new trial here. Thank you for your help.
My dates mixed up. The September date, I believe, was the September 23rd was the sentencing date. The defendant then retained Mr. Marcoux, and Mr. Marcoux filed a number of matters, both here and in the circuit court. But what is set for today is defendant's motion for a new trial. And as I indicated, there were also things filed in circuit court. The defendant contends a couple of things, primarily ineffective assistance of counsel. And other issues. He had proposed to present testimony here today regarding some of these issues.
Let's go.
I got an email, I guess early this morning, it's first I heard of it, requesting that the witnesses appear by Zoom. I thought, well, at this point, it isn't even clear they're going to be able to testify. Then shortly after that, I got a response from Mr. Gabriel objecting to that, believing that if we're going to take any testimony, it should be in person. So I excused those witnesses. Mr. Bush was also subpoenaed, and he is here. Mr. Marcoux filed a couple of things. He filed a brief on appeal in support of defendant's motion to remand for evidentiary hearing. That was filed in the circuit court. And I don't believe I ever found any order from the circuit court remanding the matter back for testimony to the district court. If there is such an order, I missed it. I'm not exactly clear what the circuit court did on this. I guess I could have looked at the record. Mr. Gabriel gave me a little synopsis of it this morning. So what is at issue here today is just the motions that were filed in the district court as a motion for a new trial. Mr. Marcoux, am I in the right ballpark or am I wandering in the weeds here?
You're completely in the right ballpark, and I'll kind of give a 3 or 4 minute explanation for the strangeness of the proceedings.
That's fine, thank you.
I think this court knows that I have done appeals for years, and I primarily do appeals from circuit court to the Court of Appeals. The particular court rules involving appeals from circuit court to the Court of Appeals has very detailed rules about when you file what types of motions, depending on appeal, where they get filed, and who gets to hear them. For instance, on a motion for a new trial, you can file it within the time period of the brief on appeal in the Court of Appeals. There's a specific court rule that says that, and you file it in a circuit court, but then you also file it in the Court of Appeals so they know that it happened. The court rules from district court to circuit court are slightly more vague, but there is a court rule that says you can do motions for new trials in the district court. And because of the fact that the court rule wasn't as abundantly clear, I thought to err on this side of caution, I'd file the motion for new trial in this court. But in case that wasn't proper, I also filed the motion to remand in the circuit court to ensure that I had covered all my bases on this. However, I am confident that the court rule, there's a district court rule, it's not really in the appellate court rules, it's in the district court rule that does provide that I can file a motion for new trial in this court. So that's why there's the different proceedings.
And you kind of explained that in your cover letter, but what's the status of the circuit court case?
Because there's a motion for new trial scheduled or set, the circuit court, there's like dual jurisdiction. They're not supposed to hear anything else until this honorable court decides the motion for new trial. Once the court decides the motion for new trial, then everything, including the original trial issues, whatever original trial issues exist, and anything that exists involving the motion for new trial, then all gets heard as one big brief on appeal to the circuit court.
Mr. Gabriel, is that acceptable to the people?
I believe that's accurate, Your Honor. Judge Stutzman and Mr. Marcoux and I were all present. I think on the other case, when we discussed with Judge Stutzman this case, and Mr. Marcoux explained to Judge Stutzman, so Judge Stutzman decided he would back off and allow you to step first.
All right. In his district court motion, the plaintiff argues that Mr. Schoolcraft his counsel was constitutionally ineffective, and he was prejudiced by the ineffective assistance of counsel, which permits this court to remand the matter to the district court. Well, that's not what we're doing here. This is his motion for a new trial. Now, I was the finder of fact in this case. This was not a jury trial. It was a bench trial. And I remember thinking at the time that the level of advocacy from two experienced lawyers, Mr. Bush and Mr. McWheel, was a pleasure to preside over that case, where I thought they each did a fine job of representing their interests. So when I was looking at this last week, and again as early as this morning, it was kind of hard for me to separate the remand motion from the motion for a new trial. In the motion, that's the remand motion. I should have printed this because I had the same problem when I was looking at it, just to look at it. Some of these matters I thought were issues that could potentially have been impeachment on collateral matters regarding the reputation of the complaining witness for violence or for truthfulness. But essentially, my understanding of this is that you claim that Mr. Bush should have done things and that he did not do them to the extent that the defendant would be entitled to a new trial. A lot of the cases that were cited had to do with jury trials, where one or more jurors might have had a different opinion had they heard other information. So specifically regarding your motion for new trial here in the district court, Mr. Marcoux, what's your argument?
My argument for why I'm entitled to an evidentiary hearing.
Yes.
Okay, understood. So this court knows that a claim of ineffective assistance requires that the moving party be able to establish at a hearing, if a hearing is granted, that there was deficient performance and that the defendant was prejudiced by the deficient performance. Deficient performance extends to not only what happens at trial, but also to pretrial investigation, preparation, interviews, witness subpoenaing. All of that can be potentially deficient performance prior to trial, and all of that plays into whether or not trial strategy was reasonable given what was done before trial to prepare for trial. Now, the Supreme Court, the United States Supreme Court, and the Michigan Supreme Court have both said that, in fact, when a defendant asserts a good faith claim of ineffective assistance, either through offers of proof, affidavits, or just assertion of facts that, exhibits attached, anything at all like that,
Thank you.
There's a critical need at that point for the court to have an evidentiary hearing. The reason is that oftentimes.
I just want to say this guy looks like a problem. Not him. This defendant. This guy looks like a problem. He either looks like he was in charge of the nuclear waste disposal for the Biden administration, or he has some troubling affiliations. Thank you guys for bearing with me. I got a mixer. It's supposed to be a nice one, but I think it was returned before, so I just hooked up directly to my mic, and I will exchange it. It's really annoying because I wanted to use it. Looks like Lennon with less hair. Yeah. So let's continue.
The claims of ineffective assistance of counsel involved facts that are not of record right now. They're just not of record. The claim is that there were facts or evidence that should have been explored. It's not on the record now. The only way to get a record on that is by having an evidentiary hearing. The case of Massaro v. United States, and in People v. Ginther, the Michigan Supreme Court case, it's clear that where there's a question of ineffective assistance, and the factual underpinnings of the issues are not currently a matter of record, the court should hold an evidentiary hearing. I will concede, Your Honor, that courts have done this in the past, either in my cases or cases that I've read, that if the court finds that even if every fact that I've asserted is true, that a defendant would not have suffered prejudice, that is the only time that I see in the Court of Appeals cases, Michigan Supreme Court, US court cases, where they deny an evidentiary hearing is they skip the deficient performance part. They skip the facts, trying to get the factual record and state, okay, Mr. Marcoux, what are all the facts you say that are relevant here? And then a court sometimes will say, even if all that were true, the defendant would not have been prejudiced by that. That's the only time that I have seen in the years that I've done this where a court does not grant an evidentiary hearing is where the court finds there's a lack of prejudice. For instance, I had a hearing in front of Judge Brickley where that particular issue arose. And in front of Judge Brickley, she made the conclusion based on other facts from trial that even if all of these facts came in, there would not be prejudice, and therefore there was no need for an evidentiary hearing. Similarly, in a case in front of Judge Smith in Berrien County, where I had a similar type argument, she found, even if you're correct, no prejudice. I then went to the Court of Appeals, filed a motion to remand. They remanded it back down and said, no, you need to have an evidentiary hearing on this because at least one of those facts, if true, could establish the requisite prejudice. So you need to have the underlying facts established in a record. So the vast majority of times I file this, courts give the evidentiary hearing to make sure the record is clear. There's no particular standard, Your Honor. I mean, I've been doing this for 30 years, and I'm wondering still.
Well, you make a point. The next court up the line would probably say, I would have liked to have had a record regarding that. The case may be close to the first version, that even if what you pled is true, it still wouldn't have changed my mind as the finder of fact, but you don't get an opportunity to make your record. There's a case from Michigan called People versus Glover. 154 Michigan Appeals 22, 1986. Says a convicted person who attacks the adequacy of the representation received during trial must prove the claim. That's also People versus Glover. To the extent that the claim depends on facts not of the record, the convicted person must move for a new trial in the trial court, which you have done, and make a testimonial record that evidentially supports his or her claim and excludes hypothesis inconsistent with the claim. So that case presumes that you would have an opportunity to make some sort of evidentiary record.
And I'll tell you, Your Honor, that even though that case exists, I mean, this court knows that I'm only going to give the court my honest opinion and what my experience
Well,
is.
it was reversed, but reversed for other reasons other than that.
So what's happened is, and I think Mr. Gabry knows this because he's done some appeals in the past, that it's not clear what I have to do to get the evidentiary hearing. Do I need to just avert facts in there? Do I need to do affidavits? Do I need to offer proofs? Do I need to do exhibits? So I try to include as much as I can through affidavits, offers of proof, and exhibits so that the court understands that there are extra trial facts that need to be explored. I'm not asking anybody to accept those facts as true and then make a ruling on my motion for new trial. I mean, there has to be a testimonial record if the court finds that there may be prejudice if any of those facts are true. But again, the only time I've seen a court deny an evidentiary hearing on this, since I've been doing this, is when the court goes to the second step and says, even if all those facts are true. And when they do that, when a court has done that with me, they've asked me to outline all the facts that I expect to be proven, and then they make their ruling. And that's kind of the process that I've gone through over the years.
All right, well, there's a couple of issues. let's assume for the sake of argument, you want to present an evidentiary record on evidence that wasn't admissible. You're arguing the witness's credibility. She didn't put her credibility at issue. This whole issue about the chipped tooth and was it chipped when or where, or is that a collateral matter? There are some allegations. You contend that Mr. Bush neglected to raise self-defense as a defense. Your client never claimed self-defense. He always claimed the accident. He never acknowledged that he intentionally hit her to defend himself.
That's a problem.
So there's a mix of things that maybe they're relevant, maybe they're not. As I said, I was the finder of fact, and it boiled down to I found that she was more credible than he was, and on several issues, I found that he was not credible. But nonetheless, I think unless I give you your evidentiary hearing, some judge up the line, either the circuit court or the Court of Appeals, is going to say you should have had an evidentiary hearing.
On at least two of the issues, Your Honor, I believe so.
Which issues do you wish evidentiary hearing on?
Well, I want an evidentiary hearing on all, but the court hit on the head a particular issue that I raised regarding her character and some of the impeachment stuff that I was talking about, not about the chipped tooth, but about other things. And there's a question about whether or not that evidence would have even been admissible at a trial. I understood that when I wrote the brief. I did my own research into the Michigan Rules of Evidence. I kind of thought through the process. And on that issue, I'm not so sure whether or not, Mr. Gabry can argue why it was or was not admissible, and the court can decide whether or not I can have that. But on the other two main issues regarding the chipped tooth, I don't believe that's a collateral issue at all because it's an aggravated assault. And the court found, in fact, that the chipped tooth was a byproduct of this particular incident. And so it's an element of the offense, first of all, so it's not collateral. And then number two, Your Honor, if I'm correct, that this tooth was chipped before this incident and then it looked, I don't want to say chipped, it had that particular deformity that you saw at trial through the exhibits and everything else, if that existed prior to this incident, then that means
don't fit, you must
that the
acquit.
complaining witness potentially perjured herself at trial. That's never collateral. Never collateral. That is the heart of what the court has to decide at a trial, is whether or not someone's telling the truth or not. And it's a fundamental fact of this case because it's an element of the offense. So that's what I believe is one of the issues. The other one is,
So what's the defect for Mr. Bush that he didn't? Now, bear in mind, there were two injuries. She also had headaches ever since this injury. And I also made a finding that that was an aggravated injury as a result of the headaches that she'd had since the hearing, since the injury. But what did Mr. Bush, he failed to adequately cross-examine on the issue of the tooth?
no, before trial, he was told that this was a pre-existing issue, that Mr. Schoolcraft, at least that's what Mrs. Schoolcraft would be testifying to. Whether Mr. Bush testifies consistently or not is a separate matter, but Mr. Schoolcraft would testify that he provided told Mr. Bush that that was pre-existing, that there were potentially witnesses who could testify to it, and that he had a photo showing, at least one photo from years before, showing that particular deformity in the tooth. And that Mr. Bush did not then do a reasonable investigation into that before deciding whether or not to present that at trial. That's the fundamental
The
issue.
complaining witness's testimony was under oath that she went for dental care a couple of days after the incident.
Okay.
I never saw any documentation that she had received it, but I believe that's what her
I'm
testimony.
assuming that's true, Your Honor.
Okay.
And what I've done and when I've thought this through, I'm assuming that's true. But just because she received dental care doesn't mean that the particular tooth that was repaired was not pre-existing before this incident. That's, that's the issue.
All right, well,
It's the
I'll-
issue whether or not the
It was
defect
stretch.
that was repaired existed before the incident or was a byproduct of that incident. That's really the issue that we have. And I would not have raised it unless I had talked to not only Mr. Schoolcraft, but other people, saw a picture. The court knows I ran him through a polygraph on this particular issue to double check it before I brought this
Well, and
before the
again,
court.
it's not his mouth. So maybe, she had a damaged tooth, but her testimony was that
Sure
it
has a
damaged it.
pretty
She went to the
mouthful of city,
dentist.
boy.
So, I'm not sure. We're gonna make an elaborate record on this, and I don't think it's gonna carry the day, but it may up the line. The other issue, as I indicated, there was a finding that she had consistent continuing headaches. And that was an additional factor for aggravated assault. All right, so that, as far as you're concerned, the chip tooth evidence is crucial to your defense.
For two reasons. One, for the element, the second one for whether or not she was testifying truthfully that that particular chip was a byproduct of this incident. I've seen the picture that was introduced at trial. I've shared that with people who've known her in the past prior to this, including her sister and Mr. Schoolcraft's son. I've looked at a picture from, might have been a cell phone picture from 2017. It's a little bit of a distance picture, but it looks consistent with what was introduced at trial. And it's a legitimate issue, whether I can establish it as something else. I mean, the court knows once people testify, you never know what you can actually establish. But it's definitely an issue that needs to be addressed, because if she, as the court knows, the court can reject someone's testimony completely if they find that they're lying about one particular fact. So that's, the second part of this, not just an element, but also the other
Bad argument.
part of this. If the court is saying that there's no prejudice regardless of that, then there's no hearing on it. That's just the reality of it, right? The court says that even if you're right, that this tooth was chipped prior to this incident or had a deformity, however you want to describe it, it would not have changed my verdict. If the court says that and makes that finding, even if you're absolutely established that clearly that Mr. Bush knew of it, the witnesses exist, they would testify consistently with that, and it still would not show prejudice, then I think that's how an evidentiary hearing does not happen. I mean, that's been my experience doing this. Okay,
All right,
make sense?
yes.
Okay, so the other question I have is, the other big issue is self-defense. And that issue has to do primarily with, as this court knows, while accident was an asserted defense in this case, admittedly, defense strategy about whether to do accident or self-defense is typically an issue of trial strategy. But until we hear what evidence Mr. Schoolcraft had provided to Mr. Bush, and then Mr. Bush's explanation about why he chose one defense or the other, it's still a pending issue that is deserving of an evidentiary hearing. And the reason why is when self-defense is raised, and there's any kind of burden of production, burden shifts to the prosecutor beyond a reasonable doubt that it was not in self-defense. And that's a high standard for the prosecutor to be able to establish. And that's why when I was thinking through this case and I was listening to Mr. Schoolcraft and I was talking to other people who know this complainant and those issues, I thought it was relevant to get an evidentiary hearing on that. I do have a third issue, and that.
Well, what I don't like about that is
Yeah.
one of the versions is perjury. Either the accident version is a lie or the self-defense version is a lie. What the defendant testified to was not self-defense. His testimony was, it was an accident. And I'm presuming, I didn't look at the police report to see what was in there. That ethical counsel is not gonna induce false testimony to shift the burden of proof. So if you're looking for ineffective assistance of counsel based on the lack of self-defense, I'm not going to be convinced on that one because the defendant never raised the defense of self-defense.
I don't believe, Your Honor, that the trial testimony is inconsistent, qualitatively and quantitatively inconsistent with the self-defense claim. He claimed that she got on top of him, started hitting him, and then
Well, yeah.
he threw his arms out.
Well, and
He says that, and that's an
all
intentional
right,
act.
so let's assume
That's
that's
an
the
intentional act.
truth. The truth is he remembers it. I heard it. It's not 6 inexperienced jurors. It was me. And I heard her version and I heard his version. So if we were to have a different trial and his version is now, I hit her in the mouth because I was defending myself. Both versions can't be true. So I heard his version and I heard her version. And there was never a self-defense component to it. It was always accident. All right.
I have a third issue.
Thing.
The third one, Your Honor, is her motive for fabricating the allegations in this case. And misstating it, exaggerating it, however you want to state it, because she was angry at Mr. Schoolcraft because she believed that he was the one who had made a phone call and caused a problem with somebody that she had a relationship with. And she told that to other people. And those people, I spoke to them, at least one of them, her sister, about that issue, that and in fact, the sister was the one who had made the phone call to the person that the complaining witness was in a relationship with. And motive to exaggerate, motive to slightly change facts, all of that is relevant at a trial. Now, again, whether Mr. Bush knew that information, whether Mr. Schoolcraft provided that information to him is a completely separate matter. If Mr. Bush says, I never heard that, I didn't know anything about that. And then Mr. Schoolcraft testifies, well, yeah, I told him that. And then it's just a credibility issue for this court to decide. But a lot of it has to do with, when you're a defense lawyer, it isn't just what you do at trial. It's what you do prior to trial in order to investigate possible defenses and then determining after you've done the investigation, what is the best possible defense.
All right. Mr. Gabriel, I guess we'll take these one by one. The chip tooth avenue, self-defense question, and motive for fabrication.
Well, I can. Can I kind of go in a little different order? Just
Yeah,
because I
fine.
got this set up.
All right.
Okay, so, that was a great conversation, and I respect Mr. Marcoux' ability as an appellate attorney.
Ooh. Somebody's got a bald spot coming in. Oof. This guy looks like he's about to convert to Judaism just to get one of those little Jew hats to cover it up.
He's obviously got a lot more of that under his belt than I even want to have. I'm a trial attorney. So when I got these motions, I look at it from the perspective of what was presented, and then I look at the law. So step number one, for your honor, People versus Simmons. It was a Court of Appeals case back in 1985. States that Ginter hearing is only warranted if the defendant is able to show a potentially meritorious, ineffective assistance of counsel claim that requires further development on the record. So step number one is we look at these allegations that Mr. Marcoux raises, and we have to make a determination as to whether or not they require further development. So in that regard, I kind of started going through the order. Number one is this argument that somehow John Bush was ineffective because he didn't create out of thin air defensive self-defense. How do I look at that? Well, obviously I look at the police report and I know that wasn't made part of the record. So instead I look at the defendant's testimony. And unless through cross-examination, the victim is shown by the defense attorney that they were that there was a issue of self-defense. I look at what this man said. The man said, well, I had a blanket, this is page 45. I had a blanket over my head. I couldn't really see where the blows were coming from. All I know is I tried putting my hands up. I had my arms underneath the blanket as well. I was wrapped up. In the process of me trying to sit up and push her off of me, that's when I heard her scream. That's not self-defense. Self-defense is an intentional act directed towards offsetting the attack. This man testified and verified, and again, if we're going to be talking about what Mr. Bush knew, he had the police report in which the same type of thing was said. How's he going to raise self-defense? The man called it an accident. He claimed he didn't intentionally hit her. He didn't do anything to put her in fear. He protected himself, and she got hit in the mouth, and there was blood, and he was a nice guy, and he helped clean it up. That's what the court heard. So to say, oh, well, John Bush was ineffective, and we need to create a record now of self-defense, I don't see how we need to create a record because the court's heard it. So I toss that one aside. Then we look at the chipped tooth issue. Again, I looked at the police report. I looked at the information that had been provided to Mr. McWhale and Mr. Bush. And I see not a deformity of a tooth being an issue. I heard the testimony of a chip to a front tooth that had to be grinded down. There's no question, and victims here today, there is an overlap of the front teeth. That's not what happened. That wasn't what was caused by this injury. She testified her tooth was chipped. Her lip was cut. There was blood. There's a small chip in the corner of the People's Exhibit 1 that you can see on, well, you saw it, Your Honor. There's a little chip. The tooth was ground down. And frankly, I think Mr. Schoolcraft knows that because I have his insurance record showing that on April 1st, the dentist billed them for the exam and the x-rays to do the repair. Can't find more because the dentist is dead. And I don't know where his records went.
Whoa.
What are we going to accomplish? Oh, yes, she had a deformity. She still does. Her tooth still has an overlap. That's not the injury here. Court saw the injury, saw the picture, and made a determination of the facts. This is a unique Ginther kind of request in that when it was raised, you were the fact finder. We're not talking about how information was presented to a jury and how other information could have affected a jury. You were there. Not only were you the fact finder, but the court, again, I reviewed it. The court, when there was an issue that it wanted to develop further, that the attorneys didn't develop, the court as a fact finder asked questions and established in his own mind what the facts were. I then go to the next two issues. One, she's got a history of not telling the truth. And that should somehow we can attack her credibility by that. Again, a whole lot of trials under my belt. Never seen it done. Don't just go after the victim and say, well, you're not a very honest person. To me, the only basis if this court needs to hear further testimony would be that somehow this man told John Bush certain things that Mr. Bush knew he should have brought forward and he had some reason not to. So that's why I want to make sure John was going to be available if those were done. But the idea of bringing in other witnesses to testify about her character, to testify about her motive, those are all issues that are raised in just about every DV case. We don't have all those collateral issues that we constantly bring in to make a relatively, at maximum, this was a 2-witness case. But apparently, from what I understand, the officer was ill or not able to proceed. So Mr. McWhale was not able to get his observations in when he saw the chipped tooth and the bloody lip. So I guess I leave it to the court. If the court feels that an evidentiary hearing is necessary, because the defendant does have this heavy burden to prove that Mr. Bush was ineffective. They have to overcome the strong presumption that defense counsel's action constituted sound trial strategy. I think that's a no-brainer on the self-defense issue. I think the chipped tooth was clearly discussed and raised and weighed by the court, along with the other injury. And the collateral matters of attacking witnesses because somebody else thinks they're not an honest person or that they have a motive to make this up. I just don't get it. It happened. Nobody's arguing that there wasn't this physical interaction between that man and her. So one person sees it one way, he sees it another way, and a fact finder determines who they believe. Thank you.
All right, Mr. Marco, it's your motion. I'll give you the last word if you have anything else to say.
Couple points, Your Honor, regarding the self-defense claim. The prosecutor cited the transcript, and that is actually an intentional act of shoving somebody off. His words were shoving, but that's an intentional act. He basically says, I'm getting her off of me. That's what he's saying, and I'm using physical force to do so. That's an assault, regardless of how you want to describe it. And that's why there was an available self-defense claim in this case, and that's what Mr. Schoolcraft has said from day one, that she was doing that, and that's why he reacted the way he did. Regarding the opinion or reputation testimony for truthfulness, that's admissible. Specific acts are not, but reputation opinion testimony is available, and Mr. Schoolcraft provided that information or at least that's what we expect the testimony to be, that he provided that information to Mr. Bush. Regarding motive to fabricate, again, that's a classic cross-examination method, and it's our position that Mr. Bush should have explored that with Mr. Schoolcraft prior to trial before deciding whether or not to do that. Whether or not he did explore it, we don't know, because we don't have a record on that. And then finally, regarding the chipped tooth, I've seen the picture from 2017, and the tooth looks the same as it did at trial. Can't say that it is because it's a faraway picture, but it's a curved tooth with ridge issues on it, and that's what it looks like to me. So I thought, her sister who grew up with her would know about that tooth, and that's an issue in this case. So I'm leaving it up to the court's discretion. The court does have discretion. This isn't something where the court has to grant an evidentiary hearing. I can see that Mr. Gabby's correct on that, but I believe I've set forth sufficient facts that additional record needs to be established.
All right. All right, let's start with self-defense. The defendant version was what you testified to, which was essentially accident. Even if you construe that as a self-defense, the defendant got to tell his side of the story. I pushed her off in response to her striking me. I don't need an evidentiary hearing regarding whether or not he would have raised the defense of self-defense. He got to tell his side of the story under oath, which I don't think constituted self-defense, but he didn't say she was going to strike me in the face, so I hit her first. Or she hit me, so I hit her back. That's not exactly self-defense. But so, no, I don't think the self-defense argument requires testimony or merits a new trial. In addition, transcript.
Come on, Judge.
Of the defendant at page 52. Line 7. You're not alleging that any of your kids hit her or assaulted her in any way, are you? No. You're not alleging that she tripped and fell and hit her face against the wall or anything like that, not to my knowledge. Line 13. So something between you and her, the physical interaction, her injuries were a result of the physical interaction between you and her. Yes. Then he goes into questions about the divorce proceeding and the fact that she was upset and there were issues regarding custody and threats to kill herself. And those were certainly issues that could go to motive or her fabrication of this fact situation. It happened, as Mr. Gabriel said. I'm trying to get to my ruling. Mr. McLeod argues at page 60, starting at line 20. Now, the statute requires that the complaining witness have a serious or aggravated injury. In this case, we have a chipped tooth, which on the face may not be much. Think about the requirements of having the dentist and having to have that tooth ground. I think that certainly qualifies as a serious injury. In addition, the complaining witness suffered I've got this thing for you. Testified that now, even today, since this incident, she suffers from headaches. And those headaches started right after she was hit in the face and caused the injury to her lips, teeth, and upper lip. I think, Your Honor, the continuance of having problems from the assault is another indication that this was an aggravated or serious injury. If you don't find serious injury, it would at least be a domestic assault. It would have been better to print this, but I elected not to do that. I guess it's my own fault. Page 69, starting with my findings at line 16. So let's talk about the actual elements of the offense. First, that the defendant assaulted Leslie Ann, or there was a battery. An assault is swinging at somebody and causing fear of an immediate battery. This isn't an assault, it's a battery. A battery is the forceful, violent, or offensive touching of a person. She got punched in the face, arguably. The touching, as the issue that Mr. Bush spoke to, touching must have been intended by the defendant, that it is not accidental. It must have been against Leslie's will. Now here is this issue. Second, at the time of the offense, the complainant was the defendant's spouse. Third, in this case, the assault carries a serious or aggravated injury, and the jury instruction defines that as a serious or aggravated injury, a physical injury that requires an immediate medical treatment or causes disfigurement, impairment of health, or impairment of a part of the body. There are two components to that. One is the chipped tooth. And I think we could provide 5 witnesses and 3 dentists to say that she had a previously chipped tooth. But her testimony was under oath that her chipped tooth got chipped and that she went to the dentist and had it treated. In fact, it was ground down.
Brown.
That was one of my bases. And any testimony that you would present would not convince me that she went to the dentist because her tooth was chipped and her lip was cut. So I don't need any testimony you would present would not be sufficient to counter her testimony that she did have a chipped tooth and she went to the dentist and had it treated and had a cut lip. So that I don't need the testimony. So even if there were such testimony, it wouldn't change my finding. But above and beyond that. Secondly, she contends to have headaches now, even months after the fact. I don't believe she got struck in the forehead, but she got struck in the mouth. And as a result of being struck in the mouth, she contends that she still has a disfigurement, impairment of health, or impairment of a part of her body. I would argue that the continuing headache is an impairment of health. So I do find that this is an aggravated injury. One, the chipped tooth, and I'm not going to be convinced by expert testimony that she had a previous chipped tooth. And 2, she had another serious or aggravated injury in the continuing headaches that she had. So that doesn't carry the day. Then the last issue is her reputation for truthfulness, and somehow that she had a motivation to fabricate this incident or alter her testimony in order to convict her husband. As I mentioned, there were a lot of weird, unanswered little portions to this case. There was his relationship with his friend that was or was not something more than a friendship, whatever relationship she had. The incident at the parking lot at work, were the kids in the car, were they not in the car, how long was the delay? The fact that all the video cameras were turned off in the house. Her contention was he turned them off because she didn't want him to see what was going on in the house while the kids were there. There were the issues of the White Claws and Trulies in the dish drain board that were never adequately explained. The fact that the defendant testified that he left the house without his phone, without his car, and walked 10 hours in March to Kalamazoo. Those were things that the court considered in trying to determine credibility of the witnesses. His contention that somehow Mr. Bush should have been able to question about a relationship she had with someone else would have induced her to give false or elaborated testimony, I also don't think is compelling. It isn't though she set up something to accuse him of doing something he didn't do. Heaven forbid, something like alleging a misconduct with the children, or theft of her property, or credit card fraud, or that sort of thing. This incident happened. There was a struggle. She got struck in the face. There was blood all over. He took the money out of the coffee can and split. So Mr. Bush had more than enough opportunity to cross-examine her on other issues regarding their relationship. And I think it's a stretch to try to elicit that she was in a relationship with somebody that would have induced her to, I'm searching for the right word, embellish her testimony so that he would be convicted. I feel there was adequate opportunity to cross-examine. So knowing that this matter is going to be appealed, my only concern would be that a future court may remand the matter back for testimony on these issues. I don't believe I need any testimony regarding the chipped tooth. You could give as much as you wanted, but your testimony under oath was her tooth was chipped and she went to the dentist to have it treated. And she had another serious or aggravated injury with the headaches. 2, that they failed to raise the defense of self-defense. It wasn't an issue. And as I said, an ethical counsel is not going to induce a false defense. The defendant got to tell his story, his version of what happened under oath, and I heard it. So I don't need any testimony regarding that. I don't find it's a basis for ineffective assistance of counsel. And finally, the issues to which you wish to impeach, I don't find I need testimony regarding those because 1, I don't know that they're admissible, and 2, he had plenty of opportunity to examine on other issues. In order for a new trial to be granted on the grounds of ineffective assistance of counsel, the mistake must have been unreasonable and the circumstances must be of the sort, but for the counsel's mistake, there is a reasonable probability that the defendant would not have been convicted. I don't find that. That's People versus Pickens, 466 Michigan 298. This was not a jury trial, it was a bench trial. And I don't think any of these three factors would, even if were admissible, been enough to change my finding. I believed her, I didn't believe him, is what it boiled down to. I did raise the jury instruction of flight. He didn't stick around, he immediately left without being able to be tracked. No phone, no car. Not a single luxury. Anyway, the issue about the cans and the drain board, the extent of the injuries, the relationship that they had, all led me to the finding that he was guilty beyond a reasonable doubt of the offense charged. For that reason, I've denied your motion for testimony and denied the motion for new trial. Hopefully, this will give you a sufficient record to appeal the matter to the circuit court. And Judge Stutzman and or judges from the Court of Appeals can weigh in on this at some later point. But it's easy to second guess, to come in and read a transcript and say counsel should have done this or should have done this. By the same token, the judge should have done this or should have done this. As I said, I thought the case was very well presented by Mr. Push and Mr. Mequio, both lawyers with more than 40 years of experience. They got to their germane issues. We didn't get lost in the weeds. The focus on were the elements of the offense met. And I believe that they were. So Mr. Gabriel had asked if you do an order denying his motion for testimony and for new trial. He can use that for his appeal to circuit court.
Thank you, Your Honor. I will do so.
Okay.
All right, we'll be in recess.
Thank you, Your Honor.
All right. I want to do one from Judge Fleischer real quick. It was kind of interesting this morning.
I'm here on Miss Gill. She said,
She was pretty. Oof. Oh. Hella's here.
Hi.
How are you?
Oh, garbage morning.
I'm sorry.
That's all right.
Well, we got a few more minutes. This one I think you might enjoy, actually. I was kind of hoping you'd be here for this. Or wanted you to be here, but I wasn't sure if you would be.
Why, thank you.
So I'm glad.
Cool.
And I hope your morning goes better.
Me too.
for a bond today, and so
In custody?
she is, yes, Your Honor. And she has one pending felony, but she's out on a bond for that one already. She just has no bond set in this case.
I've seen bond sets. I see the FSGI is at 1,000. Yeah.
Okay. I talked
It
to
must have
the-
just gotten said. I don't know.
Okay, is it a PR bond?
No. It's a
Okay.
shirt.
Okay, then if we could review it today, is that possible?
Absolutely. Do
Okay.
you mind, Deputy Etchigon, do you need a translator?
No.
Do you mind me bringing up Ms. Gill? Maria.
Is Donnie a PR bond then?
No. Initials for the kid.
Okay.
Initials or something for the kid.
And I will say this lawyer looks like she's 12.
Very small.
Very tiny.
She's mini lawyer.
I know. She's got like a sweatshirt and t-shirt on. I'm like, okay.
Oh, there is that too. She's kind of casual.
Yeah, a little casual, but
But just little.
Or maybe a first name. Initial.
yes,
If
Justin.
you.
Some of us saw this morning.
Oh, look, she's kind of looking around for mum and dad.
I know. I thought she was the defendant at first.
Very, very cute.
Oh, it gets interesting.
My initials, I'm sorry.
But the child use is,
Okay. Here she comes.
all right. Good morning, Miss Gill.
Morning, Your Honor.
I wanted to bring you out because we're talking about you, and it's only fair that you get to hear what's transpiring since these are your cases.
Yes, sir.
I want you to know, I don't know anything about your case. All I know is that you've now, as of 3/26, yesterday, you picked up a failure to stop and give information. What happened? Or, well, hold on. You have the right to remain silent. Anything you
That
say
might help.
can or will be used against you. Okay, good.
On March 25th, 2025, officers were dispatched to 15357 Wallaceville Road in Tarrant County, Texas, regarding an FSGI call. Upon arrival, the officer spoke with the complainant, who stated that she followed the defendant after the defendant's vehicle hit her twice and failed to stop and give information. The complainant stated that she was driving southbound on the Sam Houston Parkway, and the defendant failed to drive in her lane and sideswiped her, causing the vehicle damage to the right side panel of the defendant's vehicle. The complainant stated that she blew her horn several times for the defendant to stop, and the defendant refused. The complainant followed for approximately
Damn
3
horn
miles
blowers.
to 15242 Wallaceville Road, and the complainant and the defendant exited their vehicle, and the
Look, it's me.
complainant told the defendant that she hit her vehicle and needed insurance information. The defendant then told the complainant no, and that she was getting something to eat. The defendant went inside the business.
I mean, she was hungry. She was hangry.
Yep.
She doesn't have time for that.
She needs to eat every 11 minutes.
Yeah.
Exited and then entered her vehicle and attempted to drive away. The complainant blew her horn several times to get the defendant to stop and told her the police were coming, but the defendant ignored the complainant. The defendant then began to put her vehicle in reverse and proceed backwards, hitting the complainant's vehicle a second time. The
So are
complainant
you telling me that now it was intentional?
The complainant moved her vehicle to avoid being hit and followed the defendant. The complainant flagged the police down to identify the defendant as the person who struck her vehicle. The estimated damage from the complainant was around $4,000, and the defendant stated she didn't stop because she was hungry and colored.
That is the greatest excuse I've ever heard given to a cop. You know why I
The cop
pulled
was
you
probably
over?
like, fine.
Do you know why I
Fine,
pulled
ma'am.
you over today? Because I'm hungry and colored.
Okay, I'll get out of your way, ma'am.
Oh.
Colored.
Hello.
Hungry and colored. Well, I'm hungry and white.
Can you look up to see if she has a
Holy
valid Texas
what?
driver license?
Yes.
Ms. Gill, I'm
Hungry
going
and
to
white doesn't
find that
cover
there's
it.
sufficient probable cause to go forward with your case. Not
So
only
racist,
are
ma'am.
you on a felony probation for assault of a peace officer, not only are you on felony probation for injury to a child under 15, but you pick up, after both of those, an evading arrest in a motor vehicle, and now an FSGI. I am taking away your privilege to drive. You will now be signing an affidavit with me today, promising me you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive in violation of this affidavit, I will have a contempt. I can have a contempt hearing. I can have a contempt.
Don't eat me.
Finish.
I'm so
please.
sorry.
Finish.
I'm a commercial driver.
Oh, Jesus.
Really?
Yes.
Really?
Yes.
You, if you do have a CDL,
Sorry, that is correct. She does have a valid CDL.
are held to an
What the hell's a
even
CDL?
higher standard.
CDL. It's a commercial driver's license for truckers.
Right.
So to be a trucker, you have to get a CDL. It's a higher level license, which basically means like if you get a ticket, even
Uh-huh.
normal driving in your normal car, not even like your 18-wheeler,
Yeah.
you risk losing your CDL.
Okay.
The DUI standards are significantly stricter. She was a commercial driver, yes. It's a huge responsibility because, like, you have to take these tests and you have to be on your best behavior at all times.
Okay.
So if you have a CDL, doing this stuff is not good.
Okay,
Like-
that's why he just chucked a little mental.
Yeah.
Okay, because he chucks little mentals.
Well, he does
but-
do that a lot.
Yeah.
Yeah, it just made it like a whole lot worse for her. Yeah, like that was kind of the reason I never wanted, or I considered being a truck driver briefly until I learned like how strict the CDL is, and like even tickets just in your normal car.
Oh, so you need to be super fat to be a trucker.
Well, usually
I mean,
you get there
like-
after a
like
couple
it-
months.
You grow
You're
into
not-
it. Yeah.
Yeah. It's not a very athletic lifestyle.
No, no. Yeah, there's a whole look.
That CDL.
Yeah.
You now have a total of 4 open cases, one of those being this FSGI and an evading arrest in a motor vehicle.
Poor lawyer.
I am taking away your privilege to drive. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine.
This is great.
You
I truly am at a loss with the attitude.
Okay.
Truly.
Okay.
This case here, not only do we have an FSGI, but it's also alleged that you backed up and hit the person intentionally. Because-
the bailiffs are kind of
Allegedly hungry and co- So now, this is an affidavit, and I hope that you take it seriously. Because if you don't, there will truly be disastrous consequences. Ms. Gill, I want you to understand that I'm going to do everything in my power to protect my public at all costs. Do you understand?
I understand you, Your Honor.
But I was hungry and cold.
May I make argument for a PR bond, Your Honor? She's made a bond in the felony already. And even with,
What is he laughing at?
she wants a personal recognizance bond.
What's that mean?
She just goes on her way without paying any
Oh, because
money for
is he
a
going to
bond.
send her to jail?
She's in jail right now.
Oh, yeah.
Uh,
What? Sorry, why is she in jail?
she was arrested.
What,
She
for
also has
smacking into
several-
the car?
Yeah, and she has several other charges as well.
Oh.
So So this lawyer's like, oh, can we just get a PR bond where you don't have to pay any money to get out? And
Oh,
follow
not
the
pay any
court rules.
money to get out.
Yeah,
Oh, that's a bit rich.
yeah.
Right.
And the judge
I mean,
usually
applying for bond is one thing, but not.
you still
yeah,
have to
okay.
follow court rules, but you have to put any money up.
Yeah, I was wondering, like, it doesn't really, like, just like having a little dingle.
Yeah.
Little dingle, that means having a little smash,
Oh,
is not really enough to be in jail. So I did wonder why she's in jail.
just an accident, no, but like she did it intentionally as well the second
Yeah, okay.
time. That I think probably elevated it.
Really? I thought it was not intentional.
Is it there?
No, I think we're in the wrong thing.
Oh yeah, we'll have to add them.
the
Yeah.
affidavit to not drive, I expressed to her that that was a possibility of a bond condition. I've spoken with her. She has family members who can help her get to and from court. She's a single mother of 2 children. She has lived at this address here in Houston for the past 5 years. She lives with her mother. She lives with her younger brother. Has lived in Harris County her entire life. And she has, in these felonies, she's actually applied to be put in mental health court because during this incident and the felonies,
The bailiffs.
she was unmedicated and she has a history of mental health diagnoses. And so, as a client of the Harris County Public Defender's Office, we have every intention of getting her treatment for those mental health issues. But she's already made a bond in the felony, and
Gets better.
she is willing to abide by any condition that this court will impose on her. It's down to the difference between $0 and $100. And
So I appreciate your argument. She is not, she's technically, you are right on bond. My feeling is that these felony courts probably do not know that she has now picked up this case yet. So I don't know what, if anything, they're going to do when they do discover this. I find, Ms. Goucher, right? Is that what, Ms. Goucher? I really appreciate your argument going to bat for her, but I think with her demeanor, her attitude, her reckless and wanton action on the road, is that you are a danger to the public. And your bond is now set at 1,000, and I'm going to raise it to 5 because I think that you really are a danger to the public, and your attitude shows us and tells me that, hey, I'm going to do what I want to do, and that's it. And that's always, I mean, really,
don't say anything.
Don't say
how many people died this weekend on the road because of the reckless and wanton actions? All we want are our streets to be safe.
You're not helping me, Your Honor. You're not helping
Don't say
me.
anything.
I'm struggling. I'm a single mom, and I've been struggling with the courts for years already, and I'm tired of it.
Oh, the look.
Okay, I was beat, okay, in front of my children, and I was thrown on the ground like an animal, okay, and I'm tired of this. I'm tired of all of this, okay, in front of my children. My children have trauma, okay, and I have no insurance for the medication, and I have not been on the medication. I'm trying to get the insurance to get on the medication.
Ms. Gill,
Okay.
I understand that, but at some point, your actions become your own, right?
You don't understand. I'm colored. You don't understand me. You don't understand me.
colored?
I was a different color, you would.
Oh,
That's so
It's
not.
so
man.
true. It's so true. And you know this. You know what I'm talking about.
ma'am.
Of all the judges to say that to, like, he is the least
Whoa.
racist judge out there.
Look, I mean, I don't live in your country. I don't get it. I don't get it. I'm sorry. I'm the last person to be able to
Fair.
talk about this, so I can't.
The
But-
judge's face.
Yeah, judges, that's a great screenshot there. Hey, screenshot that one. Hey, get that one. Get that one right there. Hang on. Let me see if I can get
got
it
it?
for you. Let me get it for you.
Thank you.
That's a good one.
I might
That's
need to use that on
brilliant.
the thumbnail.
You just might. Wow. Yeah, look, I mean, this is just. But you don't understand. I'm colored. If I was a different color, you might understand. But okay, so I'd like her to put that actual argument towards a, as she says, I don't even like to use the word, but colored judge.
Yeah.
And see what he says. Because she's not putting forth a cohesive argument, and she needs to put one forth in court.
And
Hungry and colored doesn't hold up when you've actually went and smashed into someone's vehicle on purpose.
she sounds like she does have problems, but she's not
Yeah.
helping herself. She's making more problems.
Well, this is it. I mean, it's not the person who she smacked into their car. That's not their fault that she's hungry and colored. I do feel bad though. I mean, the thing about her children and not being able to get insurance, like that sounds terrible.
Yeah.
So I don't mean to downplay that at all.
I call out discrimination when I see it on a daily basis, ma'am. I don't care who it is. I don't care what color. They're a small farm animal. I don't care. I call it when I see it. The only thing, because I don't know them. The way I get to know them is paper. And they tell me what happens in the case. And from what I see here and what has transpired here within the last 10 minutes. Really?
Officer Harris did not read me my rights.
Well, I will let.
They've been mishandling me like this for years already, okay? I have the right to tell you this. And I'm telling you, she did not read me my rights. She just shoved me behind the officer car. I did not get a voice to speak out anything.
Yes,
She just brought me to jail.
you guys speak about that. I'll tell you, look, here's what I'm gonna do. I'm gonna leave your bond at $1,000 now. All right, I'm not gonna raise it to 5, but
Oh, you're
I can't
evil,
continue to
Trenton.
give you a PR bond.
From employment too,
Listen,
okay?
do not drive.
I
It's the
thought of
only
that.
thing I'm asking you to do.
I'm a commercial driver.
Don't pick up a new
Yes,
case
sir. Yes, sir.
and just,
Don't remind him.
all right. Come on. Justin. I didn't want you to leave because I know you've been waiting.
Oh, no. I've heard here, his appearance, was required today.
Oh, okay. Wow.
That was, wow.
And I thought the prostitute earlier in the morning was going to be the highlight of the day.
I don't want to know about your personal life.
No. Not me. I'm just saying, there was a prostitute in his court earlier. Here. I'll do this one.
Right. Yeah, that's what you meant.
Page 15, Perez, come on up.
So this will be the last one, then we'll redirect over to you.
Mm-hmm.
Good morning, Ms. Perez. Ma'am, you're charged with prostitution. You're facing up to 6 months in jail and or $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
Ella's face.
Officer, as part of a proactive prostitution investigation, was driving around the 32nd 100th block of Tidwell Road. The officer rolled down
Tidwell?
his window near the defendant, and the defendant.
Oh, yeah.
The defendant
That's
offered
where
and
you get,
agreed
that's where you
to
do well
engage
for the
in
tits.
deviant
Tidwell
sexual
Road.
conduct in the form of performing oral sex for a fee of $100.
Okay.
Wow.
Ms. Perez, I'm going to find.
Nick's mod Gigi was in the chat earlier, and she said she should have charged $1 a pound. Could have made more. Damn it, David, no. It's not my mom.
Find that there's sufficient
Oh,
probable
so
cause to go forward
bad.
with your case. I'm ordering you not to engage in like behavior. Otherwise, I will revoke your bond and put you in jail. You understand, ma'am? You need a lawyer. Can we provide you a lawyer?
Oh, yes, please.
Okay. I need you to fill out an application. Deputy Etchegorn is
We know
going to give you
how
an
you'd pay
application.
for
I
one,
need you to
so
fill it
we'll
out for
provide
me.
one.
I'll have you sign a receipt of Victoria, and then we'll have you take a seat in the jury box while we find you someone. Do not leave until you sign their bond condition. Okay.
Go ahead and sign, please. All right, Judge, next is page
Aye, aye,
23.
aye.
Walter, come on up.
All right, I gotta
Yeah, I'll send everyone over for you.
go. Okay, see you guys soon
See
for
you guys.
Coburger stream with Twiz.
Awesome.
Bye.
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 There she goes. Oh, that I love that I at the end. So those were some interesting cases. David, where am I going? You are going to Hella's stream next. It's going to be Brian Koberger. And where was he on the night of the unalivings? So it's going to be very interesting. Trenton, that was a great idea on the body cam. I should try and see if I can get that. Because, oof. All right, guys, I'm going to end now. Thanks so much for being here, and I'm going to redirect y'all over to Hella. I shall see you guys later. Bye.